Okay, let's not sugarcoat this. Losing your job unfairly, being punished without real cause, it's not just frustrating, it's illegal. Let's talk about how the Labor Act actually protects workers from unfair dismissals and dodgy disciplinary action. Section 45 of the Labor Act is crystal clear. If an employee is dismissed or disciplined without a valid reason and without following fair procedures, that action is unfair. Full stop. It doesn't matter whether they gave you notice or not. If it wasn't fair, it's unlawful. There are two key tests to check if a dismissal was fair. Substantive fairness: was the reason legit, like theft, gross insubordination, or assault? That's serious. But if it's minor stuff like showing up 10 minutes late once, you can't just fire someone for that. That's overkill. Procedural fairness: even with a good reason, did they follow the rules? You must be informed of the charge, given time to respond, and be heard. No shortcuts allowed. There are reasons that will never fly no matter what: speaking up about labor violations, giving evidence in a court or wages commission, refusing to break the law or violate a collective agreement. Union activity, yes, even just being a member. Discrimination: race, sex, political belief, religion, marital status, you name it. If any of those are used against you, the dismissal or discipline is automatically unfair. No debate. So sure, an employee can actually be summarily dismissed for serious misconduct. But here's the kicker. Even then, it's really best practice to hold a disciplinary hearing. Why is that? Well, in the eyes of the law, skipping due process like that opens the employer up to massive risk. No hearing? That's procedural unfairness right there. When a case heads to the district labor court, it's actually the employer who has to prove the action wasn't unfair, not the employee. The burden of proof, it just flips. If the court finds unfair dismissal, they can do a few things: reinstate the worker in the same or a similar job, award financial compensation for lost income, or impose a disciplinary penalty only if it's just and equitable. For unfair discipline, the court might, cancel the action completely. They could suggest a better penalty, or even bounce the issue back to the employer for review under strict guidance. When making a decision, the court zooms in on how the employer made the decision. They look at whether this same procedure was used for everyone in similar situations, whether the employer played fair with the Labor Act, and yes, whether the employee contributed to the situation. So it's not just about what happened, it's about how it happened. Dismissal isn't just about signing a letter or showing someone the door. It's really about fairness, dignity, and justice. If you're ever on the receiving end of sketchy workplace discipline, don't freeze. Know your rights. And trust me, the law is on your side when the process is foul. If this helped you out, like and follow for more straight-up takes on labor rights, workplace laws, and real talk HR. Got a topic in mind? Drop it in the comments.